looks like they are not in the holding ground here. We have a strong defense team that we do in a conservative way.
We'd also humbly request that council speaks up so that we hear what he says.
Because we can't address the topic of the police. Yeah, that's it for that. But I wanted to you know, they are not even in the hands of the police right now. They are still in the hands of the police.
Maybe for good order, we can start with the prosecution. Your Honor, my name is Mule, and I appear together with Mr. Kemo. Mr. Kemo, Mr. Owiti, and Mr. Kilambi for the prosecution. Kilambi.
Sorry.
Myself,
humble request again. May council speak up so that we are able to record what he's saying. It will be useful to us. Kindly. No, I'm not. I would like to respond to what you said. So
what I'm saying is okay. Brian Mwenda, Rachel Nyambura, Isaiah Munje, Brian Mwenda, yes. Rachel Nyambura, Isaiah Munje, Mutoni Uhuru, Isaiah Munje, Mutoni Uhuru, Tiena Monare, Mutoni Uhuru, Tiena Monare, Collins Ugutu, Tiena Monare, Collins Ugutu, Patrick Lamins, Keva Uchicho. Patrick Lamins, yeah. Keva among others. I will not allow all the people who are here. One person we have related. I will address the issue of the Constitution. I will address the issue of the presidency. If I can address the legal issues, I will address the financial questions. So we are organized. Nobody will repeat. Because we are combatant.
But it's coming up. They take me as better.
I need to bring what's attention to the following information. First, this is the first time we are meeting with our clients. They have been hidden in some car behind them, and the police have refused to allow us access. And as I'm speaking to him, there is an officer here, this one on the side, who is coming, is dropped to what we are saying, and it is unconstitutional to do so. I think it is important that the police learn to allow. He's dropping. He's listening to our conversation. I've asked him to move aside and he has refused. This one, I don't know his name. It is completely untoward and disrespectful of the court process that an officer can abuse a citizen's right to have legal counsel prior to. My next point would be, we do not have a director of public prosecutions. So I do not know who has authorized the prosecution of the, or even registration of the charges that Mr. Victor Muller is intending or proposing that they need to do. We don't have a DPP, there is no authority to charge. We must remember that this is not the normal criminal prosecution. This is a political persecution. I don't want to go to the details of the charge sheet because my colleague will. But it is important to note what I've just been told right now by my client, that they were arrested on 19th. And they are being produced in court on the 24th. In total violation of the constitutional rights. They have been held in the cattle. They have not been able to talk to anybody because their phones were confiscated. And this is what, by very similar to what we said in the earlier case. The police have this abnormal habit of confiscating people's phones so that they incapacitate them from even communicating with their lawyers, with their doctors, with their family, with their wives, with their husbands. What is Kenya going? This court must protect the rights of citizens. A country's decency is measured by how it treats the weakest, especially when they are arrested. If you look at the charges on the charge sheet, the copy we were given, they have how many charges? They have 5 counts. Purportedly committed on 2 different days. And the instructions I have right now from Mr. Njenga is that he was arrested on the 19th, taken to a place he doesn't know, and blindfolded. He's now telling me they were recording statements when they were blindfolded. The court cannot countenance this. Must reject these charges. Anyway, if you look at the entire charge sheet, irrespective of the number of counts and the number of dates of their alleged offenses, there is only one person stated as a witness, Mr. Kemboi Rob, who is a police officer. Meaning, this stated that others to be stated, they are going to be manufactured. what it means really from the face of the charge sheet is that the investigation is incomplete. Because how else is they bring state one witness who is a police officer and say they are going to state others later in life? When and why? If they had investigated the case properly, they will say we have so and so, Aaron Ruby, Mr. Mungiki, and others as the witnesses, and this Victor Mule as a witness.
We have a spy, and I think this is premature. We could have taken and for good order they make the application. We make our application. You give a consultative ruling. I thought that would be more professional and for good order.
I don't know what Mr. Mule thinks is good order if they are conducting themselves unconstitutionally. The order, good order is in the Constitution, not found inside the charge sheet. All I'm saying is that this charge sheet should be rejected. You will see duplicity. The accused persons have been held in communicado and are constitutionally beyond 24 hours. Having been arrested on a Wednesday, they would have been produced in court on Thursday or Friday latest. And lastly, Your Honor, let me say this. My heart is bleeding for this country. No, whether you put it or not, I think I need you to understand, Your Honor, with utmost respect, that we are descending into a police state. See, these fellows were brought here very early in the morning. We were lied to that they would be taken to Kahawa. I was in Kahawa. They were brought here, they have been kept in, not in the cell, but in the car, outside, some car. And I personally went there to try to see that I was denied access. What kind of country are we doing if the court can't take control of itself and its precincts? It's just like Parliament has the privileges that nobody can be arrested within the grounds of Parliament. I think nobody should be given injustice in the grounds of a court premises. These fellows have been denied their justice within court premises, and it is completely unjust. But why then lie to counsel? Why deny them access to counsel?
There's an issue of lying. That is the police. The people who arrested them.
It is important.
They're the one who, if they lie to you that they'll be taken to power, I think they're the one who lied. It's supposed to be.
No, Your Honor, I very humbly and respectfully disagree with you. It is important for you to query the police and the prosecution whether they actually say it so that you can decide whether to admit this charge or not.
Also to hear from the prosecution.
Your Honor, with your kind permission, my colleague Mr. Awit will address you, but will also address you. But we'll start with Mr. Awit.
Your Honor, Ms. Kamburugu reminds me that it's also part of the prosecution team. However, Your Honor, with a lot of humility and respect for Planet Singing Sanduku, we will pray that these proceedings be a little more organized, number one. And number two is that Mr. Ndubi should be a little more clear on the nature of the applications he's making. If I got him right, one of the applications Lanet Senior is making is that to reject the charges brought before you. And my understanding is that he's premising that application for rejection on, among other grounds, number one, a question of duplicity of the charges. Mr. Ndubi appears, I'm not sure he'll clarify, to be asking you to reject the charges on the grounds, number one, that they are bad for duplicity. And number two, that there has been a violation of certain fundamental rights and freedoms fundamental rights and freedoms under the Constitution of Kenya 2010. And finally, number three, that as we speak, there is no substantive holder of the office of the Director of Public Prosecutions. If I got him right, I would like to respond to those three issues. And as I do so, because these are very serious constitutional issues raised by the Learned Counsel, is that this court can only operate within the confines of its jurisdiction. Your jurisdiction is defined by Section 8 of the Magistrates' Courts Act. And because of the jurisdictional issue, I'll start from that. That section limits your ability to hear, entertain, and or determine 8 of the Magistrates' Court Act 2015. That for good order, you can only hear or entertain and determine issues relating to alleged violation of fundamental rights and freedoms limited to Article 25A and B. Article 25A and B of the Constitution. And so that with a lot of empathy and sympathy, anything outside that falls out of your jurisdiction, and a proper application on the basis thereof is vested in the High Court by dint of Article 1653 of the Constitution. Having said so, the officers of the Director of Public Prosecutions, or said differently, the mandate of the Office of the Director of Public Prosecutions is exercised directly by the Director of Public Prosecutions under Article 157(1), or in terms of delegated authority by officers appointed, including the Deputy Director of Public Prosecutions. We have 2 of them before you this morning. And the signer, if that were an English word, of the charges before you, the approver of the charges, Mr. Murugu, who sits before you this morning. To that extent, the charges were properly reviewed and approved. And the validity of the charges as far as the existence of a substantive holder of the office does not arise. For clarity, the departure of Mr. Nurdin Haji from the office of the DPP did not invalidate the authority of the officers of the ODPP. As correctly noted by Mr. Ndubi, the authority of the officers of the DPP is granted by the Constitution and the law being the Office of the Director of Public Prosecutions Act 2012. And does not arise from Mr. Nurdin Haji or the holder of the office. On the issue of the alleged violation of constitutional rights, including holding any of the accused person or any of the suspects, before they have taken charges, incommunicado, when we sympathize again, those are issues that this court cannot listen to because you lack jurisdiction, and with that you have to down your tools. And finally, the most important question is whether or not you can reject these charges because of the invalidity of the charges to wit duplicity. Mr. Ndubi has not described to you how the charges before you are bad for duplicity. nothing at all, apart from the statement that the charges are bad for duplicity, has been told to you. In response, the charges before you are founded are on known provisions of the Penal Code, constitutional to say the least. None of them has been declared unconstitutional. And to that extent, you have proper charges based on the law, a law known in Kenya as required under Article 52 of the Constitution. Further, under Article 89.5 of, Section 89.5 of the Criminal Procedure Code, 89.5, which is the only provision this court would invoke to reject charges. The only reason you could reject charges is that the charges do not disclose an offense known in law. Count 1 is founded on Section 89.1 of the Penal Code. Count 2 on Section 308.1 of the Penal Code. Count 3 on Section 511 as read with 510 of the Public Order Act. Count 4, which may be the newest of the charges, is under Section 4A of the Narcotic Drugs and Psychotropic Substances Act as amended in 2022. And finally, count 5 is brought under Section 77.1, which has been subject of constitutional litigation prior. And the court upheld that that Section 773 is constitutional within Kenya. Similar to Section 5, which also has been subject of litigation and has been found to be sound. To that extent, you have proper charges before you. But finally, even if there were alleged, violations of fundamental rights and freedoms as alleged by counsel, then the only remedy would not be to reject the charges, but to seek constitutional litigation and damages before the High Court of Kenya under Article 165. Having said that, we humbly ask you that for good order, let us proceed to take the plea and then handle the issues arising after we've taken the plea. Thank you.
I want 2 points. The other one, all the 5 prosecutors appearing before you are duly gazetted to conduct prosecutions. And consequently, by virtue of that prosecution, that gazettement, they are properly before you, a properly approved charges and filed with you.
This officer is harassing the land, but now he's including his medicine now, so he wants to take it away. What's it? I don't know what his problem is. This is medicine. You are not a doctor to confirm. No, it's correct. He has just received his medicine and is being taken away from him by his family.
Dealing with one thing. Those are other things to attend to. Let us have some order. If he has been given medicine to take, let him take his medicine. What you do is let him take medicine. Prosecutor, when you just tell the police, if he has been told, if he is dressed with taking that, let him take his drugs.
Yeah, it should be under that we finish this process. We are sorry for that. We are gazetted. We urge the court to take judicial notice to such gazetting. 2, the office of Director of Public Prosecution is an independent office within the meaning of Article 248(1) of the Constitution, which lists independent of 248 of the Constitution, which lists is a list of commissions and independent offices, but you will note the office of the DPP is not listed. But that Article says, except to the extent this Constitution provides otherwise. So the question is, does this Constitution provide otherwise? The answer is yes. Article 157. Article 157 Sub-Article 11 provides that the Director of Public Prosecutions shall not be under the control or direction of any person or authority. This means he is independent, and that brings the office of the Director of Public Prosecutions within the purview of Article 248(1). So we are an independent office. Being an independent office, under Article 253 of the same Constitution, the office enjoys perpetual succession. The office enjoys perpetual succession, and consequently, the departure of Mr. Nuruddin Haji as the Director of Public Prosecutions does not mean that the office ceases to exist or to function. Lastly, we urge the court to make a finding that all the allegations by learned counsel have been made from the bar. They are not substantiated. They are not on oath. And we cannot forge for their correction. These are just mere allegations from the bar. We urge the court to order that the proper forum for all those arguments is the High Court, not the Holy Court. We urge the court again to order that we take plea and we make the other applications.
I'm saying,
I'm already replying to counsel.
I didn't name my apologies, we have not repeated what Mr. Mungiki said, because if we are going to do that,
I'm not going to repeat anything. What I'm saying is, Your Honor, is that number one, this country is a democracy. I was saying that independent offices under Article 243. Look at under Article 249A and C. Those commissions and independent offices have to protect the sovereign power of the people of Kenya. Those commissions and independent offices have to promote the democratic values in the society of Kenya. Those commissions are not supposed to be subject to any other agency or authority. So what we are saying is contextualize these constitutional values and apply them to these aspects. Number one, they were arrested on 19. They are held in Makadara, no communication with family or lawyers or anybody. Nobody knows where they were. They are now being removed to court 1 week later. Even when the High Court gave habeas corpus orders, he never respected. These people are a cash pay. The High Court gave them a cash pay of 100,000 shillings. He did not respect that. Your Honor, you took can vote. The vote was to protect, promote, and preserve the Constitution. And what we are asking you now is, Councillor said that when you look at the office of the ODINGA as currently constituted, there is a problem because there is an interpretative question whether the office as currently constituted can properly refer judges against this. Because I know, even in anti-corruption cases, they cannot now file cases against anti-corruption cases because the office is not properly constituted. So we want to know how do they categorize that this one they can proceed and others they cannot proceed. So that is an issue for interpretation of the Constitution. Article 157 of the Constitution, which deals with rules of government. That's what comes against. Then we accelerate with Article 248 and 249. There is an issue which is conflicting. Now, a lower court has power, Your Honor. My learned colleague, Mr. Mungiki, we has misapprehended the Constitution. And with tremendous respect, the lower court has jurisdiction where an issue regarding the interpretation, application, and the enforcement of the Constitution has arisen. It refers that matter to the High Court for proper adjudication. So what we are saying is this. Now that there is a serious constitutional issue that has arisen, you reject the charges under Section 59.5 as my learned colleague says of the CPC, so that you refer this matter to the High Court, you are to make the subject parties to bond, who are already on bond, and the cash paid from the High Court, then this serious constitutional question be answered by the High Court. Then we can come back to you and tell you that, Your Honor, the High Court has directed that you can proceed, or that matter is settled. That's one thing that I want to put to question.
You know, even as counsel proceeds, we understand this is an interjection. I'm allowed to do so, Senior. Senior, I have to
He has no audience, Your Honor. If you say no,
yes.
He has no audience, Your Honor.
Just I want to hear what we want to say.
My interjection is we understood the senior counsel to be responding to our arguments. He can only do so on a point of law and cannot raise a new issue. The issue of sending a reference to the High Court did not arrive. How do we get a chance to do that?
He misunderstood the application by Ndugu. Ndugu said this charge sheet.
And number two, Your Honor, Senior, I'm not done. With respect, you're my friend.
No,
number two is that you are being told about the issue of an order. You're not being told that any one of us here was served with any order. And the nature of that order. We haven't seen the order. And that has been raised again in response.
There is an order from the High Court.
So we plead that this court takes charge of its proceedings and ensures that the rules of the game are respected.
It's what you're saying.
Your Honor, I've given you a copy of the order and I've given you a copy of the order. The High Court had been rated through habeas corpus number E, 270 of 2023, gave the applicants, the subjects cash bill of 100,000. I've given you a copy. Yes. So that one I wanted to raise it after. But now that in the course of arguments, it's not that you are aware. And we served it their email address immediately. Yes. Yes. So these subjects are already admitted. So what we are saying is this, Your Honor.
I've seen from the church, these are issues we do very well. But I've seen that made an application to oppose one of the issues to the police of Let us wait.
We wait, yeah, that one. I've not mentioned that. And you can say I'm very organized and systematic. I've not mentioned anything which has not been mentioned by Mure or Obu, because I'm replying. So I know my boundaries. So what I'm saying is this, Your Honor. These constitutional aspirations are not just paper aspirations. They are meant to be exposed. It is the courts which expose them. And that is the enduring value in our constitutional system. That's why people respect us, that Kenya is governed by the rule of law. But if police are allowed to just come and arrest you, and they plan you with anything, even when you have never smoked in your life, they will say you were found with Musokoto. And that's a lie. And it must be said all a lie. And yet we carry Bibles to the church on Saturday and Sunday. So let me concentrate on my reply. So what I'm saying, Your Lordship, is this. If you look at section 134 of the CPC, it is very clear. That I understood Mr. Luke that when you bring a church before a trial, the statement of the church and the material particulars must be so clear so that the suspect is able to appreciate what charges are being laid against him. Then he is able to understand and prepare. If it's a matter that can take him to the gallows, he appreciates that fact from the worst. That is what I understood my learned colleague raised. So, and looking at the charge sheet, on the face of it, there is a problem. The material particulars and the statement of the offense is not even consistent. It does not comply with the section Article 50, clause 2B of the Constitution, which is very clear. 2B is very clear. The statement of the offense and the material particulars must be very specific so that it's understood. That is what counsel says, that this charge sheet does not meet that legal threshold. So, what are we saying? As at the moment, there is no proper law of charge sheet disclosing an offense before you to warrant you to take the charge. You are due now under Article 1 clause 3, I think C of the Constitution, as read with Article 159A, is you have powers from the people of Kenya. You declare that these subjects go home on reasonable cash bail, they will attend court or whatever they want. Whenever they want, they will report. But they will report as and when needed until proper charges are brought. Not these concocted charges, Your Honor. This is a democracy. So we are beseeching you, if you look at our article, Article 10, look at the preamble, look at the Article 20, clause 1. And I want you to read them. When you read them, it says, state officers, including judicial officers, are obligated to preserve, promote, fulfill, and protect the suspect. Yes. So, Your Honor, you are not writing, but I hope you do. Yes, I can also I'm a good student.
What I'm saying is, I pretend the principles and values of God, and I know them.
Because only if you are not writing, how will you remember?
I will remember.
After we finish it, we will have nothing in the record. Yes. So what I'm saying is this. We have come before. The Lord of Abraham has given this position is here now, today, so that the history is on your side. You can either build it yourself, so that you are a better and excellent judicial officer, or you can also be among the statistics that you once served in the judiciary.
Your Honor, I don't know
That is a
whether
fact.
the court should take it.
I'm not reporting that.
Yes.
Yes.
I don't understand a lot of it. Until you determine these issues you have raised, let's now try to see the way forward. And I think I'm right here is the objection.
In fact, what we are saying in order is already bail.
It's okay.
You cannot intervene in application because you are bail.
No, we have not even gotten to that.
Yes. So I'm asking you that you will make a finding that these charges violate section 89(5) of the CPC and you reject them. So that you will give further orders.
I've recorded all that.
Yes.
Just exactly. When they were arguing, and I am seeking leave of the court to answer That's one.
Perhaps, Your Honor.
Of course, leave.
It's okay. It's okay.
No,
Before you say.
I want us to have some more.
Don't allow, they are not going to speak. They are not going to judgment. You are ruling.
No, the only thing I was requesting, I think I had you mentioned that there is an application or an affidavit of posting
No,
bail.
what I'm saying,
An affidavit of posting bail, which I
I've
would
looked at
not
the
see.
judge. What I'm saying is that the judge sheet is here. And when I've looked at it before I came in, so I saw this application. So I'm saying, let us go in and see, let's get there first.
Unfortunately, we haven't been served.
We have
That's the
served.
point.
We served this time. We served.
Oh, they served.
And look, we served this on it.
No, I have seen.
I apologize.
Thank you, sir.
I apologize.
So, Your Honor, may I address those one
What
issue?
issue do you want to address?
They have talked about cases of anti-corruption not being brought to them.
No.
I will tell you
No.
why. Because it's a legal point.
It's okay, that one, I'm not even, I did not even record it.
Thank you, Your Honor. We are guided. We are guided.
So, I think we let us get to that point. What I'm saying, and these are getting various offenses. I've looked at the charges, and the has raised some issues which need to be examined, and the prosecution has responded to them. I'll defer this plea to 1:45 p.m. I'll make a ruling, and just go quickly make a ruling on those issues, then I'll come back. 1:45 p.m.
Most of them. Remind me later in the evening.
Usielewa watu kuingia. Usiwache watu kuingia, watajaa kote. Watu wakae nje. Wakili Odieki anaitwa hapa, Wakili Odieki. Anaitwa na chama. Mwambie anaitwa na chama ni Maina Njenga. Kwani iko nini? Nilikwambia uweze kufa kutoka asubuhi mpaka jioni.
We still have some pending things that we are still apologizing for the inconveniences caused to us by the system, but we will be taking that exam. So any other person who is starting to see us, the panel, please, we will start taking research. Maybe after meditation after this project. Okay? So please carry on.
Kuna mara tulienda Kifibwa beti likataga narusha pia kama kalian ndio sio
like you, and you are not living it like this. When you invoke all constitutional provisions, you know
by the defense staff if it is agreed and the risk what the judges claim rights are violated and there is no substantive order of the prosecution to approve the judges report. On the back issue, that is on whether the judge sheet is reflects the rule on the dismissal of the judge sheet is that the prosecution must not allege the commission of two or more offenses in a single charge in a judge sheet. And the importance of this is that a person judged in criminal offense is entitled to know the crime that they have committed. So as to prepare evidence. And these are charged with 5 counts. The first one is being in possession of offensive weapons. The second one is preparation to commit a felony. The third one is organizing an unlawful assembly. The fourth one is trafficking in narcotic drugs. And finally, subversive activities. You know these charges, the particulars are set out clearly in the charge sheet. And in my view, I do not see any justification in the charge sheet. And this is an argument that and the argument that the same as duplex is not correct. As to the second issue on the violation of the person's rights, that they have been watched for more than 4 hours, my view is that if that is the position, the remedy lies in action for damages against the authorities, the relevant authorities, and the same cannot be a ground for court or judge. On the issue that there is no substantive order of the Office of the Director of Public Prosecution, the previous order of that office has been taken, and it is clear that that Office of the Director of Public Prosecution is established under Article 157 of the Constitution. It is an independent office. Then we have Article 263 of the Constitution, which deals with the cooperation of commissions and independent offices. And that is very clear that such commissions and independent offices are about to cooperate with the perpetual succession at sea. It is therefore clear that the mere fact that there is no substantive order of such an office does not mean that such an office shall cease to function until a substantive order is appointed. After all, there is delegation of function in the same office, and it is therefore not true that the judges before the court were not properly approved. And having said that, I now direct that the judges be read out to the accused in the language which they understand.
You are most obliged.
Maina Njenga. Dan kita Choroke Amunya. Felix Ratu Latishe. You are Kiswahili. So, nimeshtakiwa na shtaka la kwanza, na shtaka lenyewe ni kwamba umeshtakiwa na kosa la kupatikana na silaha hatari kinyume na sheria kifungu cha 89(1) ya sheria za uhalifu wa Kenya. Na maelezo ni kwamba nyinyi watatu tarehe 20 Julai 2023 katika eneo la Kiserian area ya Jaro County bila sababu yoyote mlipatikana mkiwa na silaha ambayo ni panga ama machete 14, kisu za Wamasai 24, rungu 46 na jembe, yani miti ya jembe 3, na katika mazingira ambayo ilikuwa inaleta maswali maswali kwamba mlikuwa mnatayarisha kufanya kitu ambacho ni mbaya na kwa njia ambayo haikubaliki na sheria. John Maina Njenga, kweli ana siku Peter Njoroge Kabunya, Felix Ratu la kisha kuna shtaka la pili, na shtaka la pili ni kosa la nimeshtakiwa na kosa la kujipanga kufanya uhalifu kinyume na sheria kifungu cha 88(1) ya sheria za uhalifu. Na maelezo ni kwamba nyinyi watatu tarehe 20 Julai 2023 katika eneo la Kiserian, Kajiado County, mlipatikana mkiwa mmejihami na silaha hatari ambayo ni shete 14, visu vya Wamasai 24, rungu 46 na jembe kama miti za jari ya tatu na katika mazingira ambayo ilikuwa inaashiria mtaka kufanyia uhalifu. Ni kweli kama si kweli? John Maina, Peter Njoroge, Felix Ratu. Kuna shtaka la tatu. Shtaka lenyewe ni kwamba mmeshtakiwa na kosa la kupanga mkusanyiko wa watu ambao ni kinyume na sheria ya uhalifu, kifungu cha 5(11) ikisoma na kifungu cha 5(10) ya usimamizi wa umma sheria za Kenya kifungu cha 56. Na maelezo ni kwamba ninyi wote watatu tarehe 20 Julai 2023 katika eneo la Kiserian, Kajiado County, mliweza kupanga mkusanyiko wa watu ambao ni kinyume na sheria ambayo ilikuwa imepangiwa ifanyike Nairobi City County na maeneo mengine nchini Kenya. Ni kweli kama si kweli? John Maina, Peter Njoroge, Felix Ratu. Shtaka la nne ni kwamba tumeshtakiwa na kosa la kusafirisha madawa ya kulevya kinyume na sheria kupambana na madawa za kulevya. Na maelezo ni kwamba umeshtakiwa na kosa la kusafirisha madawa ya kulevya kinyume na sheria kupambana na madawa ya kulevya, kifungu cha 4A nambari 4 ya 1994 na ile amended 4 ambayo ni 4A subsection 2 ya 2022. Na maelezo ni kwamba ninyi watatu tarehe 19 Julai 2023 katika eneo la Kiserian, Kajiado County, mliweza kupatikana mkiwa na madawa ya kulevya ambayo ni bangi yenye ilikuwa inatoshana na gramu 1224 yenye thamani ya shilingi 36,720, na pia mlipatikana na cocaine yenye uzito wa 400 gramu 486 yenye thamani ya shilingi 1,944 yenye thamani ya shilingi milioni 1,944,000 yenye ilikuwa imefungwa kwa plastic bag na ilikuwa gari aina ya Toyota Hilux registration number KCJ 413X. Ni kweli kama si kweli? John Maina, Peter Njoroge, Felix Ratu. Shtaka la mwisho na shtaka la 5, mmeshtakiwa na kufanya matendo ya nafasi za kidi kinyume na sheria kifungu cha 77(1) ikisomwa na 77(3)(b) ya sheria za uhalifu. Maelezo ni kwamba ninyi watatu tarehe 20 Julai mwaka huu katika eneo la Kiserian, Kajiado County, kwa nia ya kuchochea watu wafanye upiganaji wa umma, mliweza kupatikana mkiwa mmejihami na silaha ambayo ni mashete 14, panga za Wamasai ama kisu za Wamasai 24 na rungu 46 na jembe 3 kama miti ya jembe 3. Ni kweli ama si kweli? John Maina, Peter Njoroge, Felix Ratu.
The information of the court, Your Honor, before my colleagues address the court, kindly place on record Sharon O'Keefe, part of the defense team, and Mayora. Sharon Otieno, and Ayora Miguel, both appearing for the accused person. Colleagues can proceed to address you.
Most of the and we have an application in district today. My colleague Mr. Temo will give the same. Temo.
What it does, I have a late court. Advice that friends here. Niti ya jembe ni kunipinga.
Your Honor, the application before you is the one dated on the 4th of July. And it's a notice of motion, 24th of July. It's a motion brought principally under 24 and 25, 24, 25, Article 49 of the Constitution, 24, 25, 49, 1, F and G, Section 36A, and Section 123A of the Criminal Procedure Act, the laws of Kenya. Your Honor, in the motion, we seek foremost to have this court deny the first accused bail. We do not object to the second and third accused being released on bail. We'll also be praying that if the court deems it fit, may grant whatever order it may deem just to grant and expedite. The application is supported by the affidavit of Chief Inspector Mutembei, and it raises issues we think are compelling, we submit are compelling to persuade this court to deny the first accused person bail. We are also submitting, Your Honor, that there is a real likelihood that the first accused person is likely to commit additional or further crimes going by his character and antecedents, having recently been charged as recent as early as last month on 20th of June in Nakuru CM criminal case number P1171 of 2023. John, Maina, Njenga, and 11 others. And we have attached that to the affidavit of Chief Inspector Mutembei. Rob is an investigation officer attached to the Serious Crimes Unit at the Directorate of Criminal Investigations, headquarters, and is the one responsible for the investigation of this matter. Your Honor, in his affidavit, he deposes that on the 18th of July, the DCI received some intelligence reports that a group of people were planning to commit crimes, including grievous harm, causing malicious damage to property during the demonstrations that had been planned last week. Yes. So, Your Honor, without repeating, let me just point out the compelling reasons. At paragraph 5, it is deposed that offensive weapons were recovered from the accused person. The charge sheet has indicated there were 14 machetes, 24 Masai swords, and 46 rungus and jembe sticks. We have attached the photograph of the offensive weapons recovered as KR1. I've also alluded, Your Honor, to the case that is before Nakuru Court. It is a case similar to the case before you, and it just goes to prove that the accused person, the first accused person, is a repeat offender. While the charge is pending, but I've not said that he's a convict.
The accused in this matter has not been convicted by any court. He is not a convict.
I'm saying, we cannot proceed like that. Let him address the court. After he's finished, we will give you time to address.
Well guided now.
Your Honor, there's a case that I've already alluded to, 1171 of 2023, pending before Nakuru, that is based on similar circumstances and facts as this one. The point I'm making is the prosecution reasonably apprehends that if the accused person is released, he is likely to continue committing these offenses to the detriment of the public. Because we all know what the court takes judicial notice of what was happening in the country last week. There was chaos everywhere. And it is the responsibility of the government to ensure that there is peace and tranquility throughout the country. The other reason we raise, Your Honor, is that the first accused person is a very influential person.
They must object to that kind of submission. Because being influential, even you are influential.
You know, we know there's nobody here. I think everybody knows it. So when you think it's, I'm not saying that I'm buying what you say, but everybody knows it.
Being influential, Your Honor, that's not really.
Okay, fine. Let him finish.
And the point I want to make about him being influential is that he is likely to instill fear and harm the witnesses that will come before this court to adduce evidence in the charges that have been laid against him this afternoon. Chief Inspector Kipkemboi also reposes that from their intelligence reports, there is a likelihood that the accused person's lives could be in danger if they are released. The first accused person. From other, it is there at paragraph 9, from other outlawed sects that could pose danger to him. The last reason we raise, Your Honor, is that there are accomplices of the accused who are still at large, yet to be arrested. And the release of the first accused person, whom I've already submitted, is influential, may prejudice the efforts to arrest these accomplices who are still at large. May we urge this court, Your Honor, to find that the reasons adduced in the affidavit of Chief Inspector Kipkemboi and the arguments we've made before you make compelling reasons that, and we pray that you be persuaded to deny the first accused bond. That is all.
What you are just wait out something before you start. So with the record I have, we have 14. No, just 1 minute. 1 minute, yes. There are 14 advocates appearing for the accused person. You cannot address me, all of this. So I want the accused to address the court.
Kindly give us 1 minute. We decide on that on the same. We've already decided on 3.
On who is presenting his we are organized. Mr. Ngunyi will finish dealing with the tire. We know what to do. Yes. You know the issues is I never want to discuss three. Only three, as I've said, only three. Yes. It is going to very quickly, I'll deal with the constitutional question, we'll deal with the legal question, we'll deal with the factual, and then is that correct? Now, I'm starting with the constitution related with the parent law. Your Honor, we submit that as a matter of course, even without us asking, you have to admit all the accused persons. It's a constitutional right. If you look at Article 49, clause 1I, it is very clear. You will not be given any compelling reason. The order compelling is something so violent that if it shook us in this house, the eyes will fall down. That's compelling. Compelling if somebody is calling witnesses, or he has sent the money through M-Pesa, that is compelling. Compelling is not an imagination of an individual or his whims. So, secondly, Your Lordship, if you look at Article 50, Clause 2A, there is a constitutional presumption of innocence. Everybody is presumed innocent. So that even if they have been charged, the Constitution protects them through the presumption of innocence. So they are presumed innocent until this trial is concluded. And for that reason, Your Honor, we pray that the victims are paid. 3. If you look at Article 50, Clause 2J and K, it says you must have time to study the charges and prepare the questions so that they are able to interrogate the evidence. They cannot do that in the community of prison. They do that better when they are released so that they can be able to prepare for their defense. 4. Look at Article 27, Clause 1, 2, 3, and 4. Article 27, Clause 1, 2, 3, and 4. It is very clear. You cannot discriminate. These rights are related to the individuals. And you cannot apply double standards as the Constitution is trying to argue, that you can separate in one transaction which happened at the same time allegedly, and then you separate that accused to one, I don't know what, and for your information, as an officer of the court, I can share with you that in that case of Nakuru, they have not supplied the defense with trial documents. We were meeting on the 18th of this month. They requested the court that they give us more time to supply the documents. I'm shocked to receive the documents in this case, yet in Nakuru, they have not supplied those documents. The court can take judicial note on that fact. And you can even call your colleague in Nakuru. They have not. And even skinned them alive, that they cannot play around with the courts. Your Honor, you are not an extension of the police agents. You are not an extension of the people. You are independent and impartial under Article 160. So you look at all the circumstances of this case independently and they come with an independent examination. That 4-3, Your Honor, and we will know any constitutional questions. Look at Article 19(1) of the Constitution. It will present that the Bill of the Law, Article 19(1), the Bill of Rights, Your Honor, is an integral part of our framework, our social and economic framework, so that nobody can try to separate the Bill of Rights from you. You have to address it. Look at that, Article 10, Clause 2C. It says the entirety of the process must be transparent, open, and accountable. So that, Your Honor, if the police are trying to hide something, or the people think, you tell them no, Look at the Constitution, Article 10, Clause 2C. It says the intensity of the process from initiation. These suspects have been held in Kumekucha since Thursday on 18th night. Now they waited until midnight to call in the police on 19th, but they took them at 8 p.m. Time started counting immediately arrested them. They should have managed an open process so that if the family is calling them or anybody wants to see them including counsel, they should allow them. They never did that. Now, these suspects are subject to the court. There is no business of trying to tell us again that the police are ready to deal with them. So you determine these issues according to your oath in the Constitution. Your Honor, I take you to Article 21.1. Article 21.1 is very clear. It states that every state officer, including judicial officers, including individuals, he must observe, promote, protect, fulfill the values and the principles in the Constitution. What are those values? They are those values of fair trial, fair values of access to justice. There are so many. We are saying this. These people have not committed treason. And even if they committed treason, they are still allowed to be released on board. Your Honor, Article 24 limits the rights. But Your Honor, it says, it is very clear, Article 24, I think 24, close to 4. It says, the limitation should not be such that it changes the character of the right. The operational term, Your Honor, is the right to a fair trial and the right to liberty is sacrosanct. It's very fundamental and paramount. So, Your Honor, I rest my case because I believe that the Constitution gives you enough powers to make them without discrimination and the international good practice because our authorities, developed by Kenyan judges, have been quoted in Zambia, South Africa, and New Zealand. Not because we are very special, because we have followed the rule of law. We have followed what the courts decide. We have never gone the way of whims in individuals or impunity. So, Your Honor, I urge you to allow application for bond for all accused persons. Finally, I wish to address the fact that I gave you a copy of the ruling of the High Court, which shows that they were admitted by the High Court bond. Your Honor, for wisdom and the consistency in terms of coherence of developing the criminal jurisprudence, it is important that you allow, my learned colleague was going to address that issue, but now you have limited us to 3. That's why I'm taking to mention it, that if you will allow him to produce the authority, it will not take a lot of time on my behalf, Mr. Mungiki, so that he will explain to you that the High Court has given board. For consistency, in terms of criminal jurisprudence, it is only good order that you maintain that jurisprudence of consistency. Because law has a modicum of order. You can know where to find it. You can go to the Act, go to the Constitution, go to judicial presidents and find it. But these other issues are not settled. You have to run around looking for them. So at least let us settle that giving them bond is a settled issue. These are the issues we can agree. So I've donated my minute to just police so that they can deal with the law and facts. Okay, let me produce it on his behalf. Your Honor, the High Court have given you that, and this is now judicial president. Yes, this is the petition number E001 of 2020. You look at it number, petition number E001 of 2020, and particularly I want you to look at paragraph 28. Because I don't have time, it is a petition. It's the last case, Maina the petition versus the Machakos County Government and the AG. And if you look at paragraph 28 and paragraph 31, they are of relevance to this case. So So I urge people to allow all accused partners to board. This will be board. I will allow my learned colleague to deal with the legal issues. Then my learned colleague will conclude unpacking the facts of this case.
Your Honor, my name is Brian Maina. I'm a brother. I would like to bring the court to the attention of the affidavit, the supporting affidavit of CFK Kimboi Rob. And I go straight to number 4. Number 4. Paragraph 4. It says that on the 20th of July 2023, the 3 accused persons were arrested at Kiselu. I would like to correct, I would like to indicate to have the court note that that is incorrect. Our clients were arrested on 19th. So this...
Your Honor, sorry to interject. We respect that information, but counsel cannot say it. He should have an affidavit stating what he said. Those are matters of practice. And we respect him while he says that, but he cannot. The rules of the game,
they
can't say
only served us with application, so it is only fair that we mention it. Because if they are presenting something verbally and it's contradictory to what is on the affidavit, which I was going also to highlight, there are quite a number of facts that are not in alignment. So it is not good practice, and it is not in the interest of justice that we allow that to decline to listen to hear.
Even again, unfortunately, counsel cannot give us matters of the facts from the bar. If he wants time to respond, he can seek time to respond and bring in an affidavit. He cannot speak to facts. He cannot. He was not there during the arrest, for example, so he cannot speak to the arrest.
Just confirm, if you know, not bring matters which you know, I think it's correct on the matters of facts.
Now,
I
just answered.
If you look at the charge sheet, it talks about the meeting and the 20th.
And the 20th. It's a contradiction.
So that's what I'm saying. It is important, therefore, that my colleague makes the reference to the fact of instructions. Remembering that the accused persons have been held in Communicado, we were not allowed them to even to see them this morning until they came in the court. And even as I was talking to them, I was
because we start going around with the year up to 4.
During the application, they were referring to the same affidavit. They were referring, the colleague that before the meeting referred to the same affidavit, trying to persuade the court that they should deny my client bail. So it is.
When you're talking about the other issue, you're talking about the issue of arrest. When he was arrested, when they were arrested, let us do it. If you are not arrested on the day, it is there. Let them tell us that. Tell us when you are arrested. Because I'm not even know why they are arrested.
But they are here.
Yeah.
Yes, they don't have to swear. Yes. They don't have to swear. That's it.
Okay, fine. It's okay. It's okay. I've no problem with that. But I'm saying,
well, Your Honor, I proceed to the next point. In this very affidavit, the corporal, the CIP swears, I find paragraph number 12. He swears in support of the prosecutor's application to deny each of the respondents' bail. Verbally, they submitted that they are only opposing bail for the first respondent, for the first accused. So it demonstrates prejudice and abuse of the whole process, because why haven't they indicated why they've only changed their stand on the opposition of bail for only one individual in the same matter? I would also like to refer to paragraph 10. paragraph 8, that being an influential person in the Republic of Kenya and a known leader of the outlawed Mungiki sect. Now, this is speculation because it has not been proven for any court before. And it is unheard of that in any jurisdiction in the world that anyone has ever been denied bail because they are influential, or your notability provides that because of how famous you might be or well known you might be, you know that negates or it diffuses your right to bail. I would also like to refer the court to the Criminal Procedure Code Act, Section 123, which stipulates very clearly 123, the Criminal Procedure Code Act, which stipulates the charges, the crimes that one would be charged for, and the possibility of getting bond would be lower. I'll have the court know that the charges presented before this court are not stipulated in that act. The act also gives this court jurisdiction and autonomy to give favorable and not excessive bond terms to all accused persons with respect to what I just mentioned up there, that what they are charged with is not included in the very exempt circumstances where people are denied. I'd also like to highlight to the court that in the same nature, that the first accused person is a very well-known person, and therefore he's not a flight risk. Why am I saying this? I'm saying this because if you're notable, it is incredibly difficult to I'm just presenting an option. Let me proceed to the next point. There's a clause, there's a paragraph that indicates that he might intimidate the witnesses. I'll have the court know that the witness is a police officer who is armed. And the allegation on paragraph 8 that the client might cause harm, rather crucial harm to the witnesses, which I find very problematic because they're saying witnesses and the only witness that is indicated is one witness. So where is the evidence that this accused person is going to present, or rather might cause any danger or crucial harm to the witness who is an armed police officer? So I submit that if somebody alleges something, and I refer that to the Evidence Act, they must prove that indeed this individual poses a threat to the said witness. That is all.
This is an unlawful, it's illegal and unconstitutional. It is seeking to subvert the Constitution, like the same way the investigator has subverted the constitutional rights of the accused persons. And to emphasize the point that is led by my colleague, the accused person, especially the first accused person, has not been convicted of any offense. He may have been arrested, and this because this has become the police state. like I said earlier, we are going backwards rather than moving forward. The grounds are on which this chief inspector going wrong relies on are speculation. This is not what a constitution like. Neither should have given an investor, a DPP, approved such a charge sheet. But more importantly, the charges facing the accused persons are themselves dubious and doubtful. When they say he had 24 Maasai swords and Maasai wings, the charge sheet itself is closest, therefore, than this equipment that do not belong. They belong to Maasais, who are not disclosed. I don't know whether Your Honor is on social media, but we have seen, and I read the Prosecution notice, we have seen clips circulating of people of government supplying machetes to people, not to the accused persons. No, it needs to go on record. You may rule me out of order.
Your Honor, these are very learned senior colleagues. They know the rules of the game, but they keep flouting them. Council knows how we would deal with the questions of material on social media. There is no material before you, there is no certificate of electronic evidence.
JB, we appreciate you. If only you could have followed the law, we would not be here.
No. Council, I expect you, I will not
I don't want everybody to be speaking. I'm the one who said I'm not putting what you said.
Thank you.
Yes, let's take show the certificate.
I want one person to address the other.
Yes. The other point I wanted to raise is the fact, in terms of the facts on the charge sheet, they're talking about Kiserian area within Kajiado County. Kiserian area is very large. What are the particulars that will ensure that the accused persons understand the charge? Kiserian is not a constituency, it's bigger than a constituency, it's a sub-county. They are also been charged with organizing, and I think my learned colleague referred to that we know what has been happening since last week. We know who called the demonstrations of the country. It's not the accused persons. We know it's the rival things. And Azimio Party. And they don't belong to Azimio, nor are they rival. So why charge them? Then they are being charged with something very strange called subversive activities. Now, subversion, to the best of my memory, is a charge that was amended and removed from the protocol out the security sector laws amendments. But more important, the accused persons are three. Then they are the fifth account rather, suggests that they were having an invitation to incite members of the public to violence. There are no particulars in this chart that demonstrate what activity they were doing for incitement.
I don't want to stop you. Listen, you know what? the application is for vote.
Yes.
The application for, you see, now you are trying to write it and you need to invest it. And that is the thing I think about the issue, the cash does not disclose particulars and the useless, blah, blah. And I've already addressed that.
No, my point, the point I was making, so I apologize.
The point you are raising, yeah? We are not attacking the right. Wait until the right moment when you get there.
No, the point
is about the issue of whether the cash is useless or not.
This is communication again, that's what it is.
Yes.
The point I'm trying to make by demonstrating the weaknesses of this charge is that there is no likelihood of conviction, and therefore there is no need to deny anyone bail. That's the point. Yes. But lastly, yes, I'm saying that the charges are so weak that they are unlikely to raise a conviction, and therefore there is no need to deny the board. Lastly, before I give 1 minute to my colleague here, Mr. Odido, I want to say that in the application we have some photographs and some electronic documents, but there is no certificate as required under the Evidence Act. So this application must be rejected. I will not admit it also to Mr. Odido with your permission. Thank you. You know, as brief as this is one brief.
No, if you continue doing like that,
you want to just do 1 minute. I will not repeat more than 1 minute.
I don't speak what I
I will not repeat what I said. I will not repeat what I said. You want to? Other than my senior insinuating that the affidavit produced before you is not only illegal but unlawful, it is also important to note, Your Honor, that the said affidavit is only premised on 2 grounds which they are alleging. Number 1, Your Honor, the prosecution alleges before you that one of the grounds in that affidavit is that they are apprehensive. It's a mere apprehension. That is the first ground, that it is simply premised on being apprehensive. And the second ground is that they question what they call the character of the accused person before you. You know, we cannot talk about the question of apprehension at this point, because this is a settled position and settled law as we speak. The case of Oscar Sudion versus Republic, as decided by Justice Joel Ngugi, that is a criminal appeal number 208, Your Honor, number 208 of 2020. Criminal appeal number 208 of 2020. Your Honor, the court stated clearly that the prosecution cannot rely on the question of apprehension, that they're just merely apprehensive, that either the accused person will interfere with witnesses or either the accused person is in danger. They need to prove 2 things which they have not proved. That number 1, the threat must be factual. They have not proved that. And that number 2, the threat must be independent. They have not highlighted specifically which threat is this. You know, number 2, on the question of the character of the accused person, the prosecution has simply presented an affidavit before you telling you that the accused person is a repeat offender. It has been demonstrated before you. They say that and
that one
but it's okay.
And I did not even put it on paper.
They have said
it was not, it's not an offense, it's called what?
It is okay. Your Honor, they have said clearly that the accused person is of a similar character which has happened before, and that there is an existing case. But what they have not disclosed before you is the position of that case. You cannot determine that a person is of a similar character if he has not been convicted. Article 50 is clear of the rights to convict. Lastly, Your Honor, they have demonstrated that the life of the accused
is in danger because of a similar sect likely to attack the accused. They have not demonstrated to you what is this sect? Does it even exist? What's the name of this sect? Number two, what are the issues between these sects? And number three, Your Honor, what has the government or what has the Prosecution done about this illegal other sect existing? They have admitted before themselves that the accused person is a non-influential person. And as such, it is clear it is of a board, fixed board, and it's not influential. No, I'm just saying, if they've said it's a non-influential person, you know, in other jurisdictions, persons who have been admitted or who have been declared to be of a non-influential person and who can be found have been even been released on a free bond in other jurisdictions. You see? So, Your Honor, we pray that the first accused person is not on Friday. And if by any chance you are going to make a determination on the bail terms, the bond terms, we pray that the first accused person, if possible, even be released on a free bond, because he's known to the prosecution. His place where he lives, they know. Where they arrested him, they know. Where he stays and his family is. So, I will be okay.
Then I hope the court has ignored the last part. We are not in the business of knowing where people live in the prosecution.
That is your business. This is
we are not proceeding like that. No. Do you have anything to say?
Yes, please. We have
I want to response. Just one point.
No. We are not going to proceed that. I'm even added that
I apologize.
Can I try it?
One little thing. The accused persons who are admitted by the High Court, and that matter is still alive.
It has been stated, and even the ruling has been given.
Thank you. I'll try to be as brief as possible. I'll start with that last question. My name is Mungiki, OWITI. I'll start with the last question of the High Court ruling. We have been served duly with the ruling dated 21st July 2023. Indeed, granting the accused persons, the applicants, therein, miscellaneous criminal case number E270-2023. However, I would invite the court to look at order number E, and I know the court is limited in time. You'll allow me to read this. That for the avoidance of doubt, the DPP, the fourth applicant, is at liberty to present any charge, which is what we've done this morning, against the applicants in any court, which is your court, and as such, and this is very important, the trial court will be at liberty to set any new terms, bail, and this is even more important, or determine whether or not to grant bail. So they didn't bring that to you. It's deliberate and it's understandable. We pray that as far as the order is concerned, this court was allowed by the High Court that gave the orders to determine whether or not to grant bail, and therefore our application is properly followed. Articles 29, Article 27, just naming a few, and a number of other articles of the Constitution have been raised. I reiterate my submissions before you this morning that Section 8 of the Magistrates Court Act limits your ability to entertain any applications on the provisions under the Bill of Rights to Article 25A and B only. Learned Senior Mr. Mungiki attempted to invite you by the provision of Article 10 on the national, the principles and national values, that you have a right to protect the Constitution as you interpret the Constitution. The Constitution only obligates the High Court under Article 165 to interpret those other provisions of the law, including 19 and 27. Because of the limited time, I'll invite the court to look at the decision of the Supreme Court in Hussein Khalid Hussein as a double S, Khalid is KH, and 16 others versus the Attorney General and 2 others. Petition number 21 of 2017. 21 of 2017. I will invite the court to look at paragraph 118 and 119. 118 and 119. Your Honor, because of the seriousness of the push that you interpret the Constitution, allow me to read a brief of paragraph 119. This is what it says. It consequently follows that the position in which the appellant sought to clarify regarding the jurisdiction of Magistrates Court in dealing with enforcement of the Bill of Rights has since been addressed by Section 8 of the Magistrates Court Act. However, the legislation was not enforced when the appellants were first before the Magistrates Court, and the Magistrates Court at the time rightly applied the applicable law. Parliament has granted to the Magistrates Courts power to consider applications on alleged violations of the Bill of Rights, but has limited that power to only 2 rights under Article 25A and B of the Constitution. So that settles the question as to whether you can deal with those other provisions. There's the issue of whether or not there has been a limitation of the rights of the accused persons, whether properly or otherwise, under Article 24. Indeed, Article 24 of the Constitution allows for the limitation of rights. But again, as we've said, that is outside your jurisdiction. There's the question of varying dates, either in the charge sheet or the application or the supporting affidavit. As you can see in the affidavit, the date of 18 is the date of receipt of intelligence. It's the date of 18. Let me just point the court to the relevant paragraph. That is paragraph 2 of the affidavit. Indeed, the charge sheet refers to 2 dates. Count 1, 20th. Count 2, 20th, count 3, 20th, count 5 as well, 20th, count 4, 19. We invite the court to invoke section 382 of the Criminal Procedure Code, which allows for correction relating to dates and other things. That a charge cannot be invalid by dint of a wrong date. That should be read together with the power of this court of amendment of charges, which allows the prosecution or this court suo moto to direct that a charge is amended. That right and power exists until the accused person is placed on their defense. We are very far away from that. There has been a
there's some other people who know we are not going to serve one person demonstrating. The other people want to be served.
The issue of what is compelling reason and the burden of proof thereof as a recent. Plethora of cases in the Republic will have this court agree with us that while the burden of proof of the existence of a compelling reason exists and is vested in the prosecution, the standard of proof of a compelling reason is distinct from the standard of proof of a criminal case. We are simply to prove the existence of a compelling reason on a balance of probability. If I were senior Mr. Mungiki, I would say the misapplication of the law. The suggestion that we need to prove the existence of a compelling reason beyond reasonable doubt is out of law. So we argue that we have proved the compelling reasons on a balance of probability. That explains, Your Honor, why we are using the words likelihood, apprehension. Those are words that appreciate that the balance, the standard of proof of compelling reasons is a balance of probabilities. I then invite the court to look at clause 4.9c. Clause 4.9c of the Judiciary Bail and Bond Policy Guidelines. And the reason I'm raising it, Your Honor, is that 4.9c, which talks about character and antecedents. The reason we raise it is that counsel referred you to section 123, which makes a distinction between offenses and whether or not bail can be granted. Post 2010, again, because that was a misapprehension of the law, all offenses are bailable. However, clause 4.9c says that a person can be denied bail on the basis of...
The problem is the that issue.
That's a point of law.
That's
a point of law. I can raise it.
That's policy one. We have no right to respond.
You want to protect me. This is a point of law.
We have no right to respond.
No, this is a question of law. You don't have a right to respond to it. Clause 4.9 talks about denial of bail on 4.9c on the basis of previous character and antecedents. If you look at the whole of clause 4.9, it lists a non-exhaustive list.
Your Honor, we must object to this submission because that document is talking about, it's a policy document, it's not the law.
Yes.
So he can't let's just finish up what you're saying.
Your Honor, clause 4.9 of the Judiciary Bail and Bond Policy Guidelines lists an exhaustive list of compelling reasons, and therefore the suggestion that there are no compelling reasons or they have not been defined, or that if they fall down there should be disaster, does not arise. Compelling reasons have been defined both by judicial precedents and by that clause 4.9. Thank you. I'm almost done. There's the argument that the accused persons should have been given an opportunity to study charges. That is not what Article 52 expects of the court and the prosecution. The accused person should be given sufficient time to prepare for their hearing. If they are not ready for hearing today, which we don't think we are going to proceed today, they shall have time. And the advocates, now that they are before court, will have an opportunity, whether outside, after bond is granted, or within the prison, to speak to their clients so that they get instructions. Finally, Article 27 has been raised on the basis that the prosecution has opposed bail only for the first and not the second and third. It is not discrimination, even if this court were to have power to hear questions of alleged violation of Article 27. It is not discrimination where compelling reasons have been proven against one person and not against the rest. In fact, it would be an interesting argument that the defense are saying if you want to deny one, then you must deny all the three. The law contemplates that if we raise compelling reasons only against one accused person, that accused person alone should be denied bail. However, as we have already said, you do not have jurisdiction to interpret Article 27. Thank you very much.
Up to that point, this matter. I'll give a date for ruling. No, I don't think other matters for this.
You know, what we were assessing, the court unanimity can retire for 5 minutes. The court has held them.
This is a matter of exception.
No.
Kindly that.
No. I don't want to go. I'm tired of that on the issue of if it's not the issue, I would have retired now to want to do the healing on form. But not because there is other issues which may force me to go and retire and do a short ruling. Please give me time and give ruling tomorrow.
We are also requesting for the defense to supply his statements and other
Those issues, tomorrow, when I give ruling, I will give direction on how the matter is going to proceed.
And the accused is visibly unwell. He cannot even now speak well. We are requesting that the ruling tomorrow can be admitted to the hospital for that purpose. He is visibly unwell. There is no medication. Right now, we cannot even start.
No. I'm saying, one person at a time. I don't want to be addressed by everybody now. Yes. I'm saying, say the name of
the pastor.
So,
You know, I've been advised by seniors that industrial area police station. Sorry. Oh, sorry, I thought you'd invited me. My apologies.
The first accused is visibly unwell. The second and third accused have been given their medication here. Not all the medication that they require, but some of it. Your Honor, our humble application. This is not an application, this is a request. Is that we
given medical attention, preferably so they can attend to court tomorrow for
I'm advised by my non-experienced behind me that the accused persons we held at industrial area prison, which has medical facilities. If there would be need for special medical facilities, a referral will come from the prison and an order can be made accordingly.
The first accused person has his patients in the current hospital. The first investigation is even coming from the information. So for the first accused, he has his taking investigation.
Considering the request by the defense to have this person taken to the hospital. One thing I'm going to say is that I'm aware that there is a medical facility at the prison. I'm also aware, and I'm saying that because I'm in that facility. I'm aware that the officers at that facility, the person who has managed there, the medical facility, the issue is an issue that I will handle. So, for that reason, I will let that request. That is tomorrow for ruling on paying bond.
Thanks. You can have me in the morning, the family.
You can come because I know I promised you. You come because the first thing, we approach everybody in the morning, 9 a.m. Sorry? They are going to be married at the dash where
Much obliged, Your Honor, and thanks for your time. Thank you.
We are most grateful.
Thank you.
No. So, for the viewers who are watching, Maina and Njenga has been taken to remand for the case to be determined tomorrow. You'll be faced by the court on bond or so you'll be taken to so it'll be remanded at the committee prisons where thank you so much for those who kept moving with us. So the ruling will be made by tomorrow at exactly 9. And, maybe I can try to get the wakilis and to have a talk with them and see what exactly they're going to tell us. So in a short while I'm going to have an interview with the wakilis of the accused persons. Which channel? Will you be posting debates of those things? How you cannot recover those? Tunaweza ongea dakika moja? Sawa. Kuja tuongee. Tunaongea tukiwa pamoja tu. So just acha niwekele mic. Hawa ndio watapeleka hii kitu kwa dunia. Yes. Dakika moja tu. Yes. Hata hii ndio picha hapa. Agano stand. Yes. Are you ready? Are you guys ready? Just a minute. That's why were they objecting to that? It was relevant. The flight. Yes. It was quite relevant. And the resident. Yeah. Now, how was today? No, today is okay because we have seen our client for the first time. This is what they should have done on Thursday. Because while hiding, there is no reason whatsoever. If you want to charge, the process should be open, transparent and accountable. That's what the Constitution dictates. when they hide him, we suspect that they are doing illegal things. So, but you can see the team of lawyers who have defended him. It's a team of seasoned lawyers who are experienced and who have articulated the constitutional and legal principles properly. And we believe that any institution addressing its mind properly to the facts and the law will always admit them to bond. We have no doubt.
Okay, according to you, was the arrest political?
No, this is a political persecution. It's not the arrest, the entire process. We, the people, the family, and all the other people. Maina was not arrested in a road demonstrating. He was arrested in his home when he visited his father, who is ailing. He went to visit him at his home. So he was arrested from home. Are there demonstrations which happen at home, in people's homes? You see, people should not take us for granted or for idiots. This is a war between Gachawa and Maina and Njenga over some political influence in the mountain. That is the real issue here. Because in court you must identify the controversy. As far as we are concerned, the controversy here is between Gachawa and Maina and Njenga. And so long as Gachawa is pushing Maina and Njenga, we will never leave to address him. He should stop and focus on governance. Stop focusing on issues about Maina and Njenga, where he's going to shop, where he's going to church. It doesn't help him. He's high up. Let him focus on governance, diplomacy, and other things. These other things, let them leave them for MCA and MPs. But now when you lower yourself to this level, then there's a problem. That's why there's a problem in the governance structure. Because we don't know how to address challenges and complex issues. The complex issue facing Kenya today is unemployment. The other thing is the high cost of living. And if the cabinet can sit down and address that issue and give a policy framework, you think you will be interested to go to demonstrations? But because nobody is listening, people just want to exploit and persecute others because they perceive that they were in the other system. We have had 5 systems in Kenya. Are you going to do all of them and revenge? No. You start from where you were sworn in and move forward. Kenya is big for all of us. But now the problem is, because there is a problem in the mountain, there is a political problem. Because there is no natural leader. You know, these other areas have natural leaders who have taken over and the people have moved on. But the mountain, it is convoluted. But my colleagues can also address the issue and say.
Maybe just to ask, because today you've spoken so much about the constitutional rights of, that were abused by that came with the arrest.
Yes.
Is it, what are you going to do as
and also,
you know,
my name is Brian Mushira from NTV. Just also maybe to get to understand, Makwiny has been very clear on we are taking a police state direction inside the chambers. Maybe also speak into matters of that.
Okay, I will allow my colleagues to speak about the police state. But the constitutional violations, I will mention something. You know, this constitution was a negotiated document. It took 24 years to negotiate. There were several disagreements. There was Boomers 1, Boomers 2, and an universal draft. Why we could not agree is that there are some essential things that we believed were so critical that it should not be left out. One of that is fair trial. And the principles and values in the Constitution under Article 10, Clause 1 and 2. So those principles includes patriotism, the rule of law, democratic practice, transparency, openness, and accountability. So that if you are a state officer and you want to do something, you should be open, transparent, and accountable. Now the problem is, if police effects an arrest on suspicion of somebody having committed an offense, the presumption is that they have done a prima facie investigation. They have tangible evidence or a consent which you can hold on. Then they now say, let us go and arrest. But you see, they are arresting
and they have only one witness, who is a police officer, who is armed. Now they are telling us that Maina is likely to interfere with the witnesses. How can Maina interfere with a witness who is a police officer, who is armed 24/7, and is the only one? And they have taken 72 hours to get one week, so they might need about 2,000 hours to get 10 more witnesses. That is the problem we have with them. Because if they had not been prepared properly, why did they arrest? Because they could have waited. So I believe that is why we have a problem with them. My one and colleague will address the issue of the political doctrine and persecution, political persecution by the state, which is coming out, manifesting itself in this process. Because they initiate a case in Nakuru, they deny trial bundles. But when they come to Nairobi, those trial bundles for Nakuru are attached as evidence to deny. But not been given evidence in Nakuru case. So you can see they are trying to manipulate the process. So my learned colleague can respond to that.
Very briefly, my position is that Kenya is turning very fast and swiftly into becoming a police state. You have seen how many people, including Maina, Njenga and others, that the police arrest, applies to court to detain secretly because they never serve their applications. And then once the courts also comply, and I think this is an important call to our judiciary to start to be independent, and I think Martha Koome needs to listen very carefully. She needs to realize that the courts are sliding back into being tools of the executive, so that they deny people bail, they hold them for 14 days, 21 days, then they go back to court to say, oh, we have investigated, we don't have evidence. But the idea really was to detain people as they manipulate certain things. Maybe scandals are happening somewhere and we don't know. So that's why I am holding the view that when we find the office of the DPP coming to support the police action without upholding the values of the Constitution, like my colleague has said, you can see that we are actually leaning very dangerously towards the precipice. So let RUTO grow up, let Martha Koome grow up, Martha Koome grow up, let Gachagua especially grow up, so that they start leading the country and governing the country rather than ruling the country. Thank you.
And finally, just to add this, I think Kenyans should be a worried lot, and even you members of media should be a worried lot. We have seen what is happening, the trend that is now going on in this country. This government is barely 10 months in power, and this is where we are. What will happen in 3 years or 2 years to come? Who will be safe? Even the court will not be safe if they don't, if they don't put their foot down. So it is high time they decided that they want to fix this mess. It is only the courts that now we can run to. Executive, legislature, all of them now are in one thing. So Kenyans must be vigilant. We refuse to die on our knees. We will die on our feet, and all of us must fight. This is not just about Maina and Njenga. This is not just about Babu Win and other people. This is about Kenyans. The issues Kenyans are raising are valid issues that any sensible government should listen to. They should not be tear gassing us with police around here. So let them know we can only push people to a certain point. At some point, we will say no. We will say no.
Thank you.
So you've heard whatever the kind of say that they said, and there's so much that was spoken in court today, and perhaps just to tell you is that so much has been said, and we expect so much to be done in the coming days, and yes, that's what I can say for now. And thank you so much for watching. Thank you so much for tuning in. Until next time, bye-bye.
cha 4A ni nambari 4 ya 1994 na ile amended 4 ambayo ni 4A subsection 2 ya 2022. Na maelezo ni kwamba mimi watatu tarehe 19 Julai 2023 katika eneo la Kiserian County mliweza kupatikana mkiwa na madawa ya kulevya ambayo ni bangi yenye ilikuwa inatoshana na gramu 1224 yenye thamani ya shilingi 36,720.
Tunaweza ongea dakika moja? Sawa. Sini ya kazi gani sema? Safi. Kuja tuongea tukiwa pamoja pia. So this acha niwekele mic. Hawa ndio watapeleka kwa dunia. Yes. Pamoja tu. Yes. Hata hii picha hapa. Stand. Yes. Are you ready? Are you guys ready? Yes. That's why was he objecting to yes. So quite ready. And the resident. Now, how was today? No, today is okay because we have seen our client for the first time. This is what they shall have done on Thursday. Because while hiding, there's whatsoever. If you went to church, the process should be open, transparent and accountable. That's what the Constitution dictates. When they hide him, we suspect that they are doing illegal things. So, but you can see the team of lawyers who have defended him is a team of seasoned lawyers who are experienced and who have articulated the constitutional and legal principles properly. And we believe that any institution addressing its mind properly to the facts and the law will always admit them to bond. We have no doubt. Okay, according to you, was the arrest but this is a political persecution. It's not the arrest. The entire process. We, the people, the family, and all the other people. Maina was not arrested in a road demonstrating. He was arrested in his home when he visited his father, who is ailing. He wanted to visit him at his home. So he was arrested from home. Are there demonstrations which happen at home? In people's homes. You see, people should not take us for granted or for idiots. This is a war between Gachagua and the Maina Njenga over some political influence in the mountain. That is the real issue here. Because in court you must identify the controversy. As far as we are concerned, the controversy here is between Gachagua and the Maina Njenga. And so long as Gachagua is pushing Maina Njenga, we will never live to address him. He should stop and focus on governance. Stop focusing on issues about Maina Njenga, where is going to shop, where is going to church. It doesn't help him. He's all up. Let him focus on governance, diplomacy, and other things. These other things, let them leave them for MCA and MPs. But now when we lower ourselves to this level, then there's a problem. That's why there's a problem in the governance structure. Because we don't know how to address challenges and complex issues. The complex issue facing Kenya today is unemployment. The other thing is the high cost of living. And if the cabinet can sit down and address that issue and give a policy framework, you think we will be interested to go to demonstrations? But because nobody is listening.
people just want to exploit and persecute others because they perceive that they are in the other system. We have had 5 systems in Kenya. Are you going to do all of them and revenge? No. You start from where you were sworn in and move forward. Kenya is big for all of us. But now the problem is, because there is a problem in the mountain, there is a political problem. Because there is no natural leader. You know, these other areas have natural leaders who have taken over and the people have moved on. But the mountain, it is convoluted. Not as always knows it. And my colleagues can also address the issue and say.
Maybe just first, because today you've spoken so much about constitutional rights of, that were abused by that came with the arrest. Is it, what are you going to do as tunaweza ongea dakika moja? Sawa. So this wacha niwekele mic. Hawa ndio watapeleka hiyo kwa dunia. Yes. Dakika moja tu. Yes. Hata ile picha hapa. Stand. Yes. Are you ready? Are you guys ready? Yes. That's why I think yes. So quite ready. Now, how was today? No, today is okay because we have seen our client for the first time. This is what they shall have done on Thursday. Because while hiding, whatsoever. If we want to charge, the process should be open, transparent and accountable. That's what the Constitution dictates. When they hide him, we suspect that they are doing illegal things. So, but you can see the team of lawyers who have defended him. It's a team of seasoned lawyers who are experienced and who have articulated the constitutional and legal principles properly. And we believe that any institution addressing its mind properly to the facts and the law will always admit them to bond. We have no doubt. Okay, according to the arrest but this is a political persecution. It's not the arrest. The entire process. We, the people, the family, and all the other people. Maina was not arrested in a road demonstrating. He was arrested in his home when he visited his father, who is ailing. He went to visit him at his home. So he was arrested from home. Are there demonstrations which happen at home? In people's homes. You see, people should not take us for granted or for idiots. This is a war between Gachagua and the Maina and Njenga over some political influence in the mountain. That is the real issue here. Because in court you must identify the controversy. As far as we are concerned, the controversy here is between Gachagua and the Maina and Njenga. And so long as Gachagua is pushing Maina and Njenga, we will never live to address him. He should stop and focus on governance. Stop focusing on issues about Maina and Njenga, where he's going to move to shop, where he's going to church. It doesn't help him. He's high up. Let him focus on governance, diplomacy, and other things. These other things, let them leave them for MCA and MPs. But now when we lower ourselves to this level, then there's a problem. That's why there's a problem in the governance structure. Because we don't know how to address challenges and complex issues. The complex issue facing Kenya today is unemployment. The other thing is the high cost of living. And if the cabinet can sit down and address that issue and give a policy framework,
you think who would be interested to go to demonstrations? But because nobody is listening, people just want to exploit and persecute others because they perceive that they are in the other system. We have had 5 systems in Kenya. Are you going to do all of them and revenge? No. You start from where you were sworn in and move forward. Kenya is being for all of us. But now the problem is, because there is a problem in the mountain, there is a political problem. Because there is no natural leader. You know, these other areas have natural leaders who have taken over and the people have moved on. But the mountain, it is convoluted. But my colleagues can also address the issue and say,
maybe just first, because today you've spoken so much about constitutional rights that were abused by that came with the arrest. Is it, what are you going to do as tunaweza ongea dakika moja? Sawa. So this wacha niwekele mic.
Hawa ndio watapeleka kwa dunia. Yes.
Watamoja tu.
Yes. Hata ile picha hapa. Stand. Yes. Are you ready?
Are you guys ready?
Yes.
That's why I think objecting to the
yes.
It's quite red.
Now, how was today?
No, today is okay because we have seen our client for the first time. This is what they shall have done on Thursday. Because while hiding, there's nothing whatsoever. If we went to church, the process should be open, transparent and accountable. That's what the Constitution dictates. When they hide him, we suspect that they are doing illegal things. So, but you can see the team of lawyers who have defended him. It's a team of seasoned lawyers who are experienced and who have articulated the constitutional and legal principles properly. And we believe that any institution addressing its mind properly to the facts and the law will always admit them to bond. We have no doubt.
Okay, according to you, was the arrest political?
But this is a political persecution. It's not the arrest. The entire process